Good day. This is a public webinar presented by the United States Environmental Protection Agency about the CERCLA Section 108B rulemaking for hard rock mining and mineral processing. During this one-hour webinar, we will present the structure of the rule as we now envision it. The structure is not yet final, so it may change. During this webinar, you will not have the opportunity to speak, but you may type questions, which we will examine and answer as we can within the hour. This webinar is being recorded, and after the webinar, you will receive an email containing a link to the recording. In about a month, the public will be able to view the webinar on our website at www.epa.gov/superfund/policy/financial responsibility, all one word, /. Now, let's get started. We will talk today about the background of the CERCLA Section 108B Financial Responsibility Rule for hard rock mining and mineral processing. We'll talk about the structure of the proposed rule as we now envision it. And we will talk about next steps in the rulemaking. CERCLA is an acronym for the Comprehensive Environmental Response, Compensation, and Liability Act of 1980. This law is also called Superfund. During this webinar, we will refer to the law as CERCLA. Section 108B of CERCLA directs EPA to develop requirements that classes of facilities establish and maintain evidence of financial responsibility consistent with the degree and duration of risk associated with the production, transportation, treatment, storage, or disposal of hazardous substances. A key purpose of this provision is to assure that owners and operators make financial arrangements to address risks from the hazardous substances at their sites. Section 108B of CERCLA also requires that EPA issue a Federal Register notice identifying the classes of facilities for which it will first develop requirements. EPA did issue that priority notice on July 28, 2009. In it, we identified classes of facilities within the hard rock mining industry as those for which we would first develop requirements. You could see the link by which you can access priority notice on your computer. For purposes of the notice, EPA defined hard rock mining as the extraction, beneficiation, or processing of metals, for example, copper, gold, iron, lead, magnesium, molybdenum, silver, uranium, and zinc, and non-metallic, non-fuel minerals such as asbestos, phosphate rock, and sulfur. EPA also identified some classes of facilities that are not included in the rulemaking, although they did fall within that definition of hard rock mining. On January 6th of 2010, EPA published in the Federal Register an advance notice of proposed rulemaking, known by the acronym ANPRM, in which the agency identified additional classes of facilities for further evaluation and for development as necessary of proposed CERCLA Section 108B requirements. EPA identified classes of facilities within 3 industry sectors: chemical manufacturing, petroleum and coal products manufacturing, and electric power generation, transmission, and distribution. You can see the link on your screen so that you can access that notice with your computer. The agency intends that many of the core concepts of the hard rock mining proposed rule structure could carry through to future Section 108B rules that EPA determines are necessary. Now, let's talk about this proposed structure of the CERCLA Section 108B rule for hard rock mining and mineral processing. We plan to proceed from certain regulatory approach premises. We plan to proceed from two premises. First of all, CERCLA is a response program that addresses CERCLA Section 107 liabilities, response costs, natural resource damages, and health assessments, and is distinct from closure and reclamation requirements of federal and state permitting programs. Section 108B rules complement, but do not change or substitute for, existing Superfund cost recovery and enforcement procedures. The regulatory approach we are considering now is based on 5 foundational components. First, the universe of facilities to be regulated. Second, the flow of funds from the financial responsibility instrument to the CERCLA cleanup. Third, the financial responsibility scope and amount. Fourth, the relationship of Section 108B financial responsibility to state and local government law. And fifth, the relationship of Section 108B financial responsibility to other federal law. Let's talk now about the universe of facilities to be regulated. We have examined the mining facilities identified in the July 28, 2009 priority notice in order to identify classes for possible financial responsibility regulation. We are considering an approach that would identify classes of hard rock mines that the agency believes present a lower level of risk of injury and therefore would not be included in the rulemaking. Classes the agency is considering not including in the rulemaking include certain placer mines, exploration mines, and small mines that encompass less than 5 acres. Under this approach, the remainder of the hard rock mines identified in the priority notice would be included in the rulemaking. EPA would also include primary processing activities located at or near the mine sites that are under the same operational control as the mine itself in EPA's evaluation of sites for inclusion in the hard rock mining rule. Now let's discuss the flow of funds from the financial responsibility instrument, whatever that might be, to the CERCLA cleanup. We evaluated how the Section 108B financial responsibility would supplement existing CERCLA sources of funding to address releases and potential releases of hazardous substances. Under the approach we are considering now, instruments that could be used to pay into a special account for a CERCLA settlement, into a trust fund established pursuant to an administrative order, or after a court finding of CERCLA liability. EPA would use existing Superfund enforcement processes first, including settlements, orders, and cost recovery actions against potentially responsible parties to effect cleanup. Other parties, such as other federal agencies, states, tribes, and the public, could also make claims against the owner or operator under Section 107 of CERCLA that would be payable from the financial instruments. Under CERCLA Section 108C, parties, including EPA, could also bring a direct action claim against the instrument provider. Now let's talk about the scope and the amount of financial responsibility requirements as we now envision them. EPA has considered what Superfund costs should be covered by the financial responsibility instruments and how the amount of financial responsibility should be determined. EPA is considering an approach under which owners and operators would be required to provide financial responsibility instruments to cover all CERCLA Section 107 liabilities at their facilities. This would include response costs, natural resource damages, and covered health assessment costs. To determine the amount of financial responsibility required for response costs, the agency is developing a model that would identify an amount of financial responsibility to reflect the primary site conditions that may result in future costs. The model would assign values for a facility based on facility and unit characteristics, such as open pits, waste rock dumps, tailings, heap leaches, process ponds, water management, and operations, maintenance, and monitoring. These values would correspond to calculated cost levels and in turn be aggregated to form the basis for the financial responsibility amount. We intend the model to reflect the relative risk of facility practices in managing hazardous substances, including reductions in risk that may result from compliance with other regulatory requirements. The total amount of funds would be available for any future response action and would not be tied to a particular site feature or features. The agency is considering a fixed amount of financial responsibility for natural resource damages and another for health assessment costs that would be required from all facilities. These amounts may be developed separately from the model. Now let's talk about the relationship of Section 108B financial responsibility to state government law. Our current view is that evidence of financial responsibility under Section 108B of CERCLA was not intended by Congress to preempt state mining reclamation and closure requirements. In particular, Section 108B financial responsibility is designed to assure that funds are available to pay for CERCLA liabilities, whereas EPA's review to date of state financial responsibility requirements indicates that many of them are designed to ensure compliance with state regulatory requirements, and thus are not in connection with liability for the release of hazardous substances as specified under CERCLA Section 114D. EPA does plan to address this issue in the preamble of the proposed rule. Now we'll talk about the relationship of CERCLA Section 108B financial responsibility to other federal law. EPA has evaluated the applicability of Section 108B requirements at facilities where other federal financial responsibility requirements apply. We believe that Section 108B requirements, established to address CERCLA liabilities, are distinct from federal closure and reclamation requirements imposed under other statutes. It is important to note that EPA intends the Section 108B response cost amount to account for safer practices, including those required by other regulations. Moving to a discussion of potential costs to comply with the rule. We anticipate that the costs to comply with the CERCLA Section 108B rulemaking for hard rock mining will largely stem from a limited number of requirements of the rule, including establishing a cost estimate, demonstrating evidence of financial responsibility, and record keeping and reporting. The cost to demonstrate evidence of financial responsibility will depend on the cost estimate established for the facility and on the choice of method, such as the financial test or corporate guarantee, whether those will be applied, a third-party instrument, or a trust fund. We anticipate consideration of at least the following financial responsibility instruments: a surety bond, letters of credit, insurance policies, trust funds, and credit rating-based financial tests or corporate guarantees. As required under the law, EPA intends to consult with Indian tribes. We will consult with the federally recognized Indian tribes, whom we will notify in writing of our CERCLA Section 108B rulemaking. Each tribe will have the opportunity to request government-to-government consultation. Our goal is to ensure that tribal officials have sufficient information to be able to provide informed input to EPA on this rulemaking. EPA has already identified 2 tribes that have their own financial responsibility requirements for hard rock mining, and if more tribes have such requirements, we would very much like to receive that information. Now let's talk about consulting with small businesses. The Regulatory Flexibility Act, as amended by the Small Business Regulatory Enforcement Fairness Act, SBREFA, requires EPA to convene a small business advocacy review panel consisting of representatives from 3 federal agencies for proposed rules that will have a significant economic impact on a substantial number of small entities. Small entities are small businesses, small governments, and small organizations, including appropriate trade associations. Small entity representatives have the opportunity to offer individual advice and recommendations to the Small Business Advocacy Review Panel to ensure that EPA carefully considers small entity concerns. The Small Business Regulatory Enforcement Fairness Act process for the CERCLA Section 108B rulemaking has already begun. We expect it to conclude with the panel report listing recommendations to EPA. Considering now the rulemaking process, we are working now to publish a proposed regulation in August 2016 for public comment. When the proposed rule is published, everyone will have the opportunity to send comments about the proposed rule to EPA. The rule will contain instructions on where to send comments. EPA will consider all comments, and we will provide official agency responses at the time a final rule is issued, should we issue a final rule. Thank you very much for your kind attention. There's still an opportunity for you to type in questions, and we will be happy to entertain the questions at this time. I'm going to place the audio line on mute for a moment or two, but I will be back shortly. Continuing now with the webinar on CERCLA Section 108B rulemaking for hard rock mining and mineral processing, one question came in to us about access to this webinar. If you're attending the webinar, or if you registered but were unable to attend the webinar, you will receive an email containing a link to a recording of this webinar. However, if you are not registered for the webinar, the public will be able to review the webinar on our website in about a month at www.epa.gov /superfund /policy /financial responsibility, typed as one word. We are considering other questions that are being typed in by participants in the webinar. Again, I'm going to put you on mute briefly. We're proceeding, ladies and gentlemen, with the webinar on CERCLA Section 108B rulemaking for hard rock mining and mineral processing. We have a question about the small business engagement process, and here to read that question and respond is my colleague Linda Barr.
I'll start by reading the question. When will SBAR participants be identified? On June 8th, 2015, we published a news release that requested self-nominations for participation as a small entity representative, and we received a number of self-nominations through that process. The process has closed, and at this point we are beginning to compile our materials for the panel process to continue.
Once we're going to a few more moments, with webinar participants, we're going to mute the audio for a few more moments. Stand by, we will resume soon. Continuing with the Section 108B webinar, we have another question. Linda?
The question is, will the EPA promulgate a new surety bond form for the proposed Section 108B financial responsibility requirement? And answering the question is my colleague, Mike Pease.
Thanks, Linda. Yeah, we're considering potential instrument forms and specifications for not just the surety bonds, but for all the instruments in order to be able to effectuate kind of the rule structure laid out today in the webinar. Thank you.
I'm going to put you on mute once again, folks, as we continue to evaluate and structure our responses to the questions that are coming in. You're listening to the webinar for the CERCLA Section 108B rulemaking. We have been receiving questions from participants and preparing ourselves for answers. Linda, what's the next question?
Will sand, gravel, and gypsum mines be subject to the rule? And to answer the question, my colleague Barbara Foster will answer.
Okay, there's a memo that is cited in footnote 3 in the priority notice that describes the commodities that aren't included in the notice, and that memo can be found in the docket for the hard rock mining notice.
We're going to mute the audio for a few moments again, ladies and gentlemen. This is the CERCLA Section 108B rulemaking, continuing with our responses to questions.
This is Sonia Fassendal. There's a question about will putting aside money under CERCLA 108B resolve the companies from liability? And the answer to that is it's really separate. Because, as we indicated at the beginning, the CERCLA 108B requirements don't change the overall Superfund cleanup process, and when these amounts are set aside, that's not a remedy. It's just either money set aside, or if there's a financial test, it would be money covered by a financial test, but it doesn't affect the liability. If anybody else here wants to chime in, you can add anything. Okay. All right. Okay, this is Sonia with another question. The question is, will the financial assurance process be available for public comment? Yes, it will. The whole rule will be out for comment as a regulatory proposal. Okay, this is Sonia. There's also a question about the cost model and where the information comes from, and we are using the information on the types of activities that are covered when there's a Superfund response. So that's what the cost model is based on.
Okay.
Okay, we've grouped some of these questions as they're very closely related. The first question is whether the rule will apply to all hard rock mining, or will there be a minimum size of operation? For this question, I will turn to our presenter, Ben Lesser.
Thanks, Linda. I'm right now trying to find the slide. Here we are, on slide 9 of the presentation. We say that all hard rock mines identified in the 2009 priority notice would be included in the rulemaking, with the exception of certain placer mines, exploration mines, and small mines of less than 5 acres.
Okay, thank you, Ben. And a couple of other closely related questions have to do with who the presenters are for this webinar, and will the questions and answers be posted for public release. For this, I'll turn it back to Ben.
Linda, we had not anticipated making public a list of presenters today. These are all EPA staff people who are working on the regulation. They all have varying individual specialties and are working on, for example, risk analysis or the financial instruments and so on. My name, phone number, and email are on record in the public docket, so I'll be happy to provide that. My name is Ben Lesser, L-E-S-S-E-R. My email address is lesser.ben@epa.gov, G-O-V.
Okay, thank you, Ben. And I think we'll put you back on hold for a couple of minutes.
Okay. We have another question, Linda.
Okay. The question is, will the financial instrument requirements, the surety bond, letter of credit, etc., including the format or text, be available for public comment? And are they being developed with the participation of industry, that is, insurance and banking practitioners? To answer this question, I will turn to my colleague, Mike Pease. Mike?
Thanks, Linda. Yes, we do plan on proposing like the form and language of the instruments in our proposed regulations. And in terms of engaging with the financial industry, we definitely plan on doing more of that, and we have already done some of that in the past, but we plan on doing more in the near future. Thank you.
Okay. Thanks, Mike.
We have an answer to a general question that's come in from a number of participants. Barbara Foster is here to answer that question.
Yes, we have several questions regarding whether the cost model will take into account existing closure and reclamation financial assurance requirements. And the answer is that EPA intends the model to reflect the relative risk of the facility's practices, and that would include reductions in risk that might result from compliance with other regulatory requirements.
Okay, thank you, Barbara.
Barbara. We have another question. Linda?
The question is, will this program be implemented under RCRA or CERCLA? To answer the question, my colleague Sonia Sasseville will answer.
Okay, yes, so this rule, it's written under authority of CERCLA, and it will be implemented as a CERCLA rule.
Okay, thank you, Sonia.
Mm-hmm.
Linda, I understand we have another question.
Yes. Does EPA plan to engage with or consult with state mining regulatory authorities who have expertise in the area of bonding for mining operations as you develop this rule prior to the public comment period? To answer the question, Ben Lesser.
Thanks, Linda. Yes, indeed we do. We have been in touch with and consulted with state officials for quite a while now, and we plan in the near future to engage with the Interstate Mining Compact Commission, whose members are governors of the various states that have mining industry as part of their economies. And as a practical matter, the staff, the senior staff in the regulatory agencies, state regulatory agencies that affect mining will be part of the meetings, I'm sure, that we'll be holding with those folks. We have also engaged and will continue to engage with the Association of State and Territorial Solid Waste Management Officials, and have been in close consultation with them and expect to be once again.
Okay, thank you, Ben.
This is the CERCLA Section 108B Financial Responsibility Rulemaking webinar, and we're continuing to take and respond to questions from the participants. Linda?
Thank you, Ben. We've received 3 questions that very closely are related, and I'll read all 3 questions and then turn it over for answering. First question is, will the proposed language for the financial responsibility instruments be included in the proposed rule? Next question, has a mechanism been defined for release of the financial surety following closure? And the third question is, will the financial test be similar to the RCRA financial test requirements? And one additional question just came in. Can you elaborate on the credit rating-based financial tests? What would it entail? To answer these questions, I'll turn to Mike Pease.
Thanks again, Linda. Basically, the answer here is that a lot of these about the actual specifics of the instruments and how they'll operate and the specifications of any financial test. We haven't fully finalized and worked out yet, but they will be available in the proposal in a form that you can comment on. And so you'll be able to get a lot more information then. Thank you.
Okay, thanks, Mike.
We have another question from participants. Linda?
Question is, will the model be available to entities to calculate requirements on their own? To answer, I'll turn to Sonia Sasseville.
Hi. Yes, the answer to that is yes. The way that we envision the rules, it would be up to the regulated entities to take their information and calculate with the model and submit both the input information and the model results to the agency.
Okay, thank you, Sonia. Okay, we have another question that's come in. It is, for existing projects, what time frame would those projects have to put financial assurance in place? In other words, within 6 months after rule implementation. To answer this question, I'll turn to Barbara Foster.
Okay, there's a phase-in provision in Section 108B3 of the statute, and the rule will reflect that provision, but we haven't yet worked out the details of how that's going to work.
Okay, thank you, Barbara. Okay.
Linda, we probably only have time for maybe one more question.
Okay.
Before our webinar comes to a close at 3 o'clock, what question do we have available to answer?
All right. The question is, will the proposed rule assess whether there is enough financial assurance capacity in the market? To answer the question, I'll turn to Mike Pease.
Yes, thank you again, Linda. Yes, the short answer is it will. There's actually Congress has asked us, in addition to other things, to evaluate the market capacity for these financial assurance instruments. So we plan on doing that.
Okay, thank you, Mike.
Yeah, I think Congress's requirement is that we publish our analysis 90 days before the proposed rule is published. So we will be doing that. Thank you very much, Mike. It's 2 minutes before the hour. Any quick questions that we can handle? I'm going to put you back on mute for a moment, folks. Folks, we very much appreciate your kind attention and the volume of interest there is in this upcoming proposed rulemaking. We do plan another webinar in December, and as I've said a couple of times, those who are registered for this webinar, whether they were able to attend or not, will receive an email with a link to the recording of the webinar, so that will be available to you. Others in the public who are not registered for the webinar will be able to view it in about a month after it's been through an agency process for accessibility on our website. That brings to a close today's webinar on the CERCLA Section 108B rulemaking for hard rock mining and mineral processing. We thank you on behalf of all of the EPA managers and staff assembled here. We thank you for your interest. We recognize your interest, and we look forward to continuing to engage with you. Good day.